thank you very much to Bogdan and to the organizers of this conference for inviting an outsider to be with you. An outsider for many reasons, perhaps. But it's not the first time I've been here. I also, at the invitation of Bogdan, when I was on holiday here, gave a lecture at the Casa Titulescu. And all I remember there is saying in 2007 that I hope joining the EU would not make you forget international law, because I know EU law comes to dominate once people are in the EU, but it was very important that you maintain your loyalty, which has existed for decades, to international law, and I'm very pleased that this conference shows that you've heeded my advice. I've been asked to, or perhaps I asked to, but I've been asked to talk about this advisory opinion of 1989, whose title is on the wall over there, Applicability of Article 6, Section 22 of the Convention on the Privileges and Immunities of the United Nations. But of course, we all know it as the Mazilu case. I'd like to begin with, I'd like to be able to say, as others did, that this case really didn't have very much to do with Romania, but I think it's quite difficult on this occasion, and it's quite delicate in some ways to talk about the case, but I will do so. I'd like to begin with two preliminary remarks. Firstly, to say how pleased I am to see Dr. Dumitru Mazilu here. He's an old friend. I think it's almost 40 years since we first met in the 6th Committee of the United Nations, and thereafter in the Law of the Sea Conference. And thereafter I saw you on television on the 25th of December 1989 on the balcony, and now we meet again. So it's a real pleasure to see you, Mr. Mazilu, again. The second preliminary point to make about this Mazilu advisory opinion is to note the timing. The opinion was given on the 15th of December 1989. And I brought with me a book to read on the airplane about the revolution of December 1989, or the events, as I'm told it's sometimes called. And that book, the first sentence of it, states that the revolution began on the 15th of December 1989 in the town of Timișoara. I don't know if that's accurate or not, but that's what the book said. So this opinion is given, and the revolution begins. I'm not sure about the connection, but they're certainly connected in an underlying way. I think probably most people in this room know what the opinion was about, but just to mention very briefly, Mr. Mazilu at the time was a special rapporteur of the subcommittee of the Commission of Human Rights of the United Nations. He had been asked to write a report on human rights and youth. He was not allowed to go to Geneva or have contact with the United Nations authorities, and to quote from a press release issued by the United Nations when he was elected chairman of UNCITRAL, it says that before becoming vice president of Romania in 1989, Mr. Mazilu was kept in detention from 1986 to 1989 for his critical report on human rights in Romania, made in his capacity as United Nations Special Rapporteur on Human Rights and Youth. Kept in detention, I understand kept in house, under house arrest, not allowed to leave the house for 4 or so years. The Romanian authorities at the time informed the United Nations that he was very ill, something that I understand was completely untrue. the case emerged from that. The Economic and Social Council of the United Nations sought an advisory opinion on the applicability of the provision concerning experts on mission to Mr. Mazilu. That was the question that was asked. Romania made two main points. Firstly, they said that the court had no jurisdiction to give an advisory opinion because of a reservation that Romania had made to the General Convention on the Privileges and Immunities of the United Nations, specifically a reservation to the dispute settlement provision, which I'll come to. And secondly, on the substance, Romania effectively said that Dr. Mazilu's health was a matter of the internal affairs of Romania, and that for the United Nations to even inquire about it was to interfere in the internal affairs of Romania. This was a very typical argument of the time of certain states. I'd like, in the few minutes I've got, to concentrate on what the significance of this advisory opinion is, in my view. I think it's significant in three respects. For what it says about the advisory jurisdiction, something that Judge Keith stressed the importance of this morning, and despite my questions earlier, I also think is very important. Secondly, it's important for what it says about the privileges and immunities of international organizations, and particularly of that very large category of persons known in the jargon as experts on missions. And thirdly, for the light it sheds on the circumstances in Romania in the last 4 or 5 years of the Ceausescu regime. That third point is obviously not a legal point, but I think it's a very important thing that comes out of this advisory opinion. So if I could look first at what it says about the advisory jurisdiction. It really dealt with three matters: jurisdiction and propriety of giving the opinion, the wording of the question, which others have referred to, and some procedural issues. On the question of jurisdiction, as I've said, Romania argued that its reservation to Article 30 of the Convention meant that the court had no jurisdiction. If I can remind you of that reservation, it said that the Romanian People's Republic does not consider itself bound by Section 30 of the Convention, which provides for the compulsory jurisdiction of the International Court. And it went on to say that the Romanian People's Republic takes the view that, for the purpose of the submission of any dispute whatsoever to the court for a ruling, the consent of all the parties to the dispute is required in every individual case. This is a classic Soviet bloc view of the court's jurisdiction. It's stated in this reservation. A lot of the other East Bloc countries and other countries made the same reservation. Some of them have withdrawn that reservation. Bulgaria, Hungary, Mongolia, Slovakia have withdrawn that reservation, but some others who I won't name have yet to withdraw it. The court had no difficulty in saying that the question had not been asked under Article 30 of the Convention. It had been asked by ECOSOC as part of ECOSOC's own power to seek an advisory opinion, and therefore this reservation had nothing to do with its jurisdiction. But it then turned to the propriety, or admissibility if you like, but the propriety of giving the advisory opinion. And here it said, well, Romania has said that since they've not consented, and since this is a dispute between Romania and the United Nations, as a matter of propriety, the court should not give the opinion. And here the court, rather remarkably in my view, looked at the wording of the question, and it said this question is about the applicability of the section dealing with experts on missions to Dr. Masalu. It's not about the application of that provision to Dr. Masalu, and the question of applicability is not a dispute between Romania and the United Nations. Had it been application, maybe it would have been. So the wording of the question, applicability as opposed to application, seems to have been crucial in the court's mind, as an easy way anyway of saying that questions of propriety didn't arise. So it interpreted the question rather narrowly, and it was encouraged to do so by the UN Legal Counsel, the admirable late Dr. Fleischauer, in his appearance before the court. The other procedural point, which I think is quite interesting, is this is almost a case of non-appearance in an advisory opinion by the state directly affected, because Romania, although it did submit written comments, it failed to appear. I think it may have been too embarrassed to appear at the oral hearing, and the only parties, the only participants in the oral hearing were the United Nations Legal Counsel, Dr. Fleischauer, and the United States of America. So I think I almost regard it as a case of non-appearance. I drew attention to the timing of the case. And the timing's very interesting because it's on the cusp of the great changes in Eastern Europe. It's interesting that the decision of the court, which went against Romania, the advisory opinion was a unanimous one, including the Russian judge, the Soviet Union, the judge from the Soviet Union, as it was at the time, Judge Tarasov. It's almost as unanimous, as it were, as the Black Sea case, in the sense that there are hardly any separate opinions. There are, in fact, 3 separate opinions, but they're relatively minor and they're fully in agreement with the court. They just elaborate, well, almost fully in agreement. Judge Oda would have gone a lot further on this applicability application case. He would have liked to have seen more said about the application of the convention. So it's almost like the Black Sea case in that it's a consensus, a unanimous decision of the court. So I think it's quite a significant case in terms of what it says about advisory opinions generally. Turning then to the privileges and immunities of international organizations, I think it illustrates the crucial importance of privileges and immunities in a situation of extraordinary circumstances, as was the case with Romania in the last few years of the Ceausescu regime, and the vital importance, if the organization is going to be able to operate, of privileges and immunities and of being able to ensure that they are followed. And it's particularly important, of course, for what it says about the privileges and immunities of experts on missions. Article 22 of the Convention is not entirely clear, but the court clarified it in a number of important respects and in ways that really show or strengthen the protection of experts on mission. Firstly, it made it clear that it applied to a whole range of experts, including members of the International Law Commission. That's very important. And to a range of other members of a range of other bodies, but also to anyone really that the organization had to consult for an opinion in the course of its business. It also made it clear that experts on mission were not just people who went on a mission, surprisingly. They might well be at home working, and they were experts on mission. It didn't necessarily involve travel. And it said, for example, some of the privileges granted are designed to facilitate the travel of experts and their stay abroad, but others are of far more general nature, particularly with respect to communications with the United Nations or the inviolability of papers and documents. And it emphasized, therefore, the content of the privileges and immunities. And lastly, it emphasized that these applied vis-à-vis the state of nationality or residence of the person on the mission, which was something that Romania had contested. So I think this is a central decision, really, for the privileges and immunities of the UN, and in particular of experts on mission. And then finally, I said that it's important because of the light it sheds on the circumstances in Romania in the last few years of the Ceausescu regime. And it's important because it shed an international spotlight on one particular case of abuse, of persecution, if you like, of one individual. That was highlighted by this decision. It's set out in detail in the papers that are public relating to the case, and that was symbolic, I think, of a lot of things that were going on here, as I understand it, at that time. And it's quite interesting that that very same point, which I came to independently, is made in the introduction to this excellent book that Dr. Mazilu gave me yesterday, which his wife has put together, of documents. But in the introduction, there's an introduction in French, but I won't read it in French, but it makes the point that this was one example which had a particular international echo at the highest level because it's described in the work of the International Court of Justice in The Hague. To ask, or to make two concluding remarks. Firstly, if I have time, what practical effect did this case have? Well, it came on the 15th of December. It's not apparent that the Romanian authorities immediately complied with it. Indeed, 6 days later, they arrested Dr. Mazilu, and as I understand it, his family, and took them to prison outside Bucharest. They were released a day later because events were happening very rapidly at that time, but it cannot be said that it had an immediate effect. In fact, the timing was such that it really couldn't have had any effect. It would be interesting to know what would have happened in the longer term if the revolution had not overtaken it. And the second and last remark I would make is that I think it's always very interesting to understand the historical and political background to a case before the International Court of Justice. I think a book's just been published about the historical background to the North Sea Continental Shelf case, explaining why that case went to the court, what the three states were doing. There's a book being worked on which will try to set out the historical background to the Kosovo case. And I think the historical background to this case, stretching as it does really from about 1985 through to December 1989, is of particular interest. I would, for example, be interested to know what it says in the archives of this ministry about what was being done in relation to this case at the time. How seriously did the legal department, for example, take this case? What were the reactions? What were their actions within government? Maybe those documents are published, maybe those documents have disappeared, but if they're available, it would be interesting if somebody could just spend a day or two looking at them and let us all know. So I'll conclude with that. Thank you very much.